Good morning, right on time. Hope everyone had a good night. We are here this morning to begin to hear 3 revocation cases, so we will simply pick up where we left off yesterday. Mr. Knapp, will you please call the roll?
Yes, good morning, Commissioners. Thank you, Mr. Chair. Barcelona.
Here.
Braun.
Here.
Brazil.
Here.
Cooper.
Here.
Yule.
Here.
Gordon.
Here.
Johnson.
Here.
Moon. Nieto. Terrio.
Here. Here.
Mr. Chair, 13 members present.
13. Thanks, Chandler. The meeting is called to order. We are in session on the record. I am Jeff Long, Post Commission Chair. Today is March 6, 2025. It is 9 a.m. To my left is Commission Counsel Deputy Attorney General Christopher Beatty. To my right, Post Executive Director Manny Alvarez. This is the time we set aside for members of the public to comment on items on the commission agenda or issues under commission jurisdiction. Please be advised, commission cannot take action on non-agendized items. Any public comment on specific revocation cases to be heard today will be taken at the time of that case. Does anyone wish to address the commission at this time? Okay, we have someone coming forward, then let me continue. If you have a specific complaint about an officer not on today's agenda, you should file a complaint with Post or with the officer's employing agency. Staff will help you during the next break. Come forward. Yeah, come on up. I just want to remind everyone who might want to comment not to discuss pending complaints or disciplinary actions that may come before the board or commission for a recommendation. If the board and commission take action on the complaint, have a chair. You're interested in, oh no, come on up. Okay. If you will have an opportunity to speak at that time, we must observe these rules to comply with the law and avoid compromising the cases. Pursuant to commission policy, the commission chair will manage the public comment period in deference to the commission workload and time constraints. Up to 15 minutes is allotted at the beginning of each meeting for public comment. Members of the public who wish to speak should limit their remarks to no more than 3 minutes. If many people are speaking on the same topic, I may limit remarks. The meeting is being transcribed, so please speak slowly and clearly. Welcome.
Thank you. Thank you for having me. My name is Yusef Miller. I'm with the North County Equity and Justice Coalition, the Saving Lives in Custody California, and also supporting the recommendations from the ACLU San Diego County. So I'm not sure at this point whether Torrance is on your agenda to talk about Torrance, but we call on you to affirm the board's recommendations on the decertification of Joshua Settler. Is that on?
That is on our, there are
Okay.
two Torrance officers on our calendar today.
Okay, so what I'll do is then I'll speak to you directly from my perspective that we support definitely the board recommendations on a lot of the cases that you're affirming, and we ask everyone for an aye vote on a lot of those cases. So ACLU, you probably have the letter already that was sent to you by Ms. Christy Hill on the recommendations there, and also from a community perspective that I know it takes some time to get access via Zoom or whatever for the community to participate. But this is one of those important meetings that the community should have access to. And at this moment, we don't have access to participants for participation in the post. Now, there are community members who work, community members have disability issues where they can't come out and they can't participate. And we want to make sure that the community has access to understand what's going on here. I understand that when you're—
Joseph, one sec, you'd realize this is live streamed.
Yes.
Right, so people do have access if they wish to watch this.
To watch, yes, but I meant participants.
Live, okay.
Live participants.
Okay.
Yes, so a lot of my friends are watching now, and I wish that they could participate. And the participation is the key to this kind of access. And I understand that when you're in Sacramento and you're in certain places, you're in your hometown, people can participate. They know the marketing is better. But here in San Diego County, we want to participate, and as well as other counties throughout the state. So I thank you and thank you for having an open door process. But this public's comment section, and there's no public that has access to actually participate, is something we need to work on so that we can have that. And also, I would like to recommend that we have more community positions or community advisory positions into this body here. This body, as you walk in, it feels like a cop shop. And this is no insult intended, but it feels like you're walking in. I felt like I had to bring my license and registration when I walked in here with so many law enforcement officers. But what I think is that if we could have, you as a body could have a community aspect of it, so it's not a echo chamber, so that people can have a different aspect, whether it's the mental health that we talked about yesterday or any other aspect. I think is something that is required for community participation. Thank you.
Thank you, Mr. Miller. Thank you for coming. Welcome back.
Thank you so much. Thank all of you. My name is Tasha Williamson. I'm a civil rights activist here in San Diego. I echo what Yusuf Miller said, but I also want to say that you guys are failing at marketing to communities. Your marketing your display that is here of people that are in attendance shows me that you are not getting out the information in an adequate time to community members so that they can join, so that they can understand exactly what Post Commission does and why you are present in their cities. We would have a host of people in this room from the community and other communities if there was a bridge to the Post Commission, and it doesn't feel like there is a bridge to the Post Commission for community members. You all seem isolated. I've been here 2 days. No one's been inviting, welcoming. You all know that I'm not with your group, but nobody's walked up to introduce themselves. No one's walked up to say, except for a few. There have been a few. They work for you. But not commissioners. I don't know who you are except for two of you. But you need to be more inviting to what you're doing. We want to work with you, not oppose you or not understand you and then have conflict. We want to make sure that the community is very aware of what you are doing and the great work that you are doing. To decertify officers, to make sure that officers are certified and trained correctly. We want them to know that this is here. They don't know how to complain. They don't know where to go. They don't even know where you are. So your marketing strategy needs to beef up. I also would say you don't need all the staff that's here behind me. That's a waste of money. To have all the staff that's here traveling with you when they could be online, like the people that you're talking about are online viewing. If you want to bring them in to do presentations, they can do that virtually. And that saves dollars that maybe you can put into a marketing strategy. So I really hope that you all consider thinking of the community more as something that would enhance what you do and become vulnerable to reach out to the community and get into the communities that you're going to be visiting so that they know where you are and who you are, what you're doing, how to get here, where to go. It was hard to even find this place for some people. That's what they told us. So, hopefully you all will take time to look at your finances and make sure that you can put a marketing strategy in there to get community members more activated and involved with your commission. Thank you.
Thank you, Ms. Williamson. Thanks for coming again. Are there any questions for either of the members of the public who commented this morning? All right. Thank you for your time, both of you. We move now to the case review of recommendations made by the Peace Officer Standards Accountability Advisory Board. First, a few preparatory remarks. I know I said much of this yesterday, but it is necessary for the record and for today's subject officers and counsel. This is not an evidentiary hearing. The rules of evidence do not apply. Evidence is not formally admitted into the record. There is no need to make objections, and objections will not be ruled upon. Under the Penal Code and applicable state regs, this hearing only determines if the matter will proceed to a full evidentiary hearing before an ALJ to determine whether the allegations are true and justify discipline. I must emphasize at this point, the commission must only consider facts that the division, after investigation, believes can be proven at a later evidentiary hearing. Today, the commission will consider arguments as to whether or not those facts, as presented by the division, demonstrate a high probability that serious misconduct has occurred. This finding results in the matter being moved forward, and no actions by the commission prior to a full evidentiary hearing constitute a final determination that an officer engaged in serious misconduct. At the conclusion of each law enforcement consultant presentation, the commission will have the opportunity to ask questions. Then we will ask for comment from the subject officer and/or their counsel, followed by comment from members of the public. Further discussion by the commission will follow if necessary. The commission may then choose to go into closed session or wait until additional cases have been presented before adjourning into closed session. After reconvening, motions will be considered. The first case, Joshua Satterfield. Law enforcement consultant Robert Bringolf and Professional Conduct LA County Bureau and Bryant Henley, Post Legal Affairs Bureau, will report on case 2305109, Joshua Satterfield, who at the time of the events in question was employed with the Torrance Police Department. The board recommendation to the commission was a unanimous revocation. Gentlemen, the floor is yours. Welcome.
Thank you, Chair Long. Good morning, commissioners. As stated, my name is Robbie Bringolf. I'm an investigator assigned to Los Angeles County Professional Conduct Bureau. I am here with respect to the case of Post v. Joshua Satterfield, formerly of Torrance PD. In this case, the division found reasonable grounds to believe that Officer Satterfield engaged in serious misconduct in violation of Penal Code Section 13510.8B5, alleging that Satterfield engaged in a demonstration of bias when he sent racist text messages to his coworkers. In the division's investigative summary and findings, it recommended revocation of Officer Satterfield's post-certification. This matter was heard by the Peace Officer Standards Accountability Advisory Board in January of this year. And following the conclusion of that hearing, the board voted to revoke Mr. Satterfield's certificate. The division asked you to adopt that recommendation today. I'll now present to you the case as I presented the case before the board. Before I do so, I do want to indicate there is some language that may be offensive to a majority of the people in this room. So just steel yourself for that, please. Mr. Satterfield began his law enforcement career with the Los Angeles County Sheriff's Office as a deputy trainee on January 9th, 2014. He was promoted to deputy sheriff on June 1st, 2014. He had 10 days off between working as a deputy sheriff and starting as a police officer at the Torrance Police Department. He holds a post-basic certificate, which was issued July 14th, 2015. On March 26, 2023, Torrance Police Department reported allegations of serious misconduct against Mr. Satterfield to post pursuant to California Penal Code Section 13510.9A3. The allegations stem from the discovery of homophobic, transphobic, and racist texts sent between members of the TPD, Torrance Police Department, between May 2018 and February 2022. When analyzing the serious misconduct allegation of Penal Code Section 13510.8B5 and Regulation 1205A5, which is the demonstrating bias sections, the division evaluates whether the subject officer, through words, action, or other conduct, has shown prejudice, intolerance, contempt, or hatred towards a protected class of persons. If the subject officer did show prejudice, intolerance, contempt, or hatred towards a protected class of persons, the division then considers whether the words, action, or conduct would lead a reasonable person to conclude that the officer has not or will not fairly and impartially perform the officer's law enforcement duties. If so, serious misconduct is shown if the officer's words, action, or conduct either 1, violate applicable law, 2, violate department policy, or 3, are inconsistent with the officer's obligation to carry out the officer's duties in a fair and unbiased manner. So during the analysis of each instance of potentially biased behavior, the conduct was analyzed based on the guidelines I just mentioned to determine whether the allegation of bias was true to a clear and convincing standard. We'll get into the messages. Regarding a message on August 23rd, 2018, Torrance Police Officer Chavez sent a text to Officer Satterfield that was a link to an article titled, quote, "Grand Rapids man accused of urinating on Black child, calling her N-word," end quote. Chavez wrote, quote, "Josh when he's older," end quote. Satterfield replied, quote, "What's the crime?" End quote. The exchange between Officer Chavez and Officer Satterfield is inherently offensive and racist. Satterfield's conduct in sending the message, "What's the crime?" in response to an article describing allegations of an adult male urinating on a female child and calling the child the N-word clearly shows prejudice. Even when viewed in the light most favorable to Officer Satterfield, the "what's the crime" response shows Mr. Satterfield's indifference toward a specific protected class. That necessarily erodes the public's confidence in Mr. Satterfield's ability to fairly perform his law enforcement duties. This message constitutes the demonstration of bias. It's also highly probable a reasonable person would conclude that Mr. Satterfield's August 23rd message, the "What's the crime" message, demonstrates that Mr. Satterfield has not or will not fairly and impartially perform his law enforcement duties when interacting with a protected class of persons. The message exchange and his "What's the crime" response violated several of the Torrance Police Department's policies, including but not limited to Torrance Police Department's anti-harassment policy and general orders, and I list a few of them in the ISF. Accordingly, the division finds that Satterfield demonstrated bias with the meaning of Penal Code Section 13510.8B5 and Regulation 1205A5 when he responded, "What's the crime?" to Officer Chavez's message. Another message on which we focused was a December 13th, 2018 message in which Officer Chavez sent a group text thread a photo from the social media account of a T-Flats wrapper that contained an image of an assault rifle sitting upright on a table with a target underneath. After some discussion back and forth, Satterfield messaged the group, "You happen to notice the rounds put through that target on the table? I'm confident he won't be hitting any of us with that unzeroed EOTech. Kind of reminds me of Chandler's targets, by evidence of," and then he named a member of the Torrance community that I referred to as IP1 in the division's investigative summary and findings. Officer Chandler responded, "I'm a dead-eye shot, biatch. Who's IP1? Officer Satterfield replied, "That niglet you failed to kill. Grandma said you need to be a better shot." Mr. Satterfield's message clearly shows prejudice and intolerance. He refers to a member of the Torrance community as "that niglet" and goes on to criticize Officer Chandler because he failed to kill that person during a previous police encounter. Even when viewed in the light most favorable to Mr. Satterfield, his racist epithet used to describe a member of the Torrance community and statement that Officer Chandler failed to kill the Torrance community member shows his indifference toward a specific protected class, which necessarily erodes the public's confidence in his ability to fairly perform in his law enforcement duties. A reasonable person would conclude that Mr. Satterfield's message shows he has not or will not fairly and impartially perform his law enforcement duties when interacting with certain protected classes of persons in the Torrance community. The specificity of the language in this exchange is severe, as Satterfield asserts that Officer Chavez failed to kill a member of the Torrance community, an individual Satterfield identified using an offensive term associated with that community member's apparent race. Coupling the racist epithets with the implication that the appropriate outcome to a use of lethal force is the death of the suspect rather than stopping the threat also suggests a reasonable person would conclude that Satterfield's statement reveals a predisposition to use force in an unfair or biased manner. Stated another way, a reasonable person would also conclude that Satterfield believes the appropriate use of force will depend on the suspect's race. Statement violates several department policies and discredits the Torrance Police Department in potentially irreparable ways. Satterfield's remarks violated several of the Torrance Police Department's policies, including their anti-harassment policy and several general orders. Accordingly, the division finds that Mr. Satterfield demonstrated bias with the meaning of Penal Code Section 13510.8B5 and Regulation 1205A5 when he wrote, "That niglet you failed to kill, Grandma said you need to be a better shot." On April 30th, 2019, Torrance Police Officer Nelson shared a Black Lives Matter Instagram post to the boys group chat. And I put that in air quotes. The post read, "Torrance, California police shot and killed," I've omitted the decedent's name, "within 15 seconds. Just released body cam footage shows police murder," the decedent's name. Mr. Satterfield replied, "Ah, and his little son will grow up without a father now. Oh, wait, that's standard for any African-American family to be absent a father. He'll be fine," end quote. Mr. Satterfield's April 30th message shows prejudice, intolerance, contempt, and hatred towards a protected class of persons. Mr. Satterfield facetiously laments the death of a member of the Torrance community by messaging "aw," and then goes on to reinforce racist stereotypes and expresses a callous indifference concerning the future of the decedent's child when he states the decedent's little son will grow up without a father now. Satterfield reacted to the death of a member of the Torrance community by using racist stereotypes, while at the same time displaying no empathy for the decedent's young son. A reasonable person would conclude that Satterfield's message demonstrates he has not or will not fairly and impartially perform his law enforcement duties when interacting with certain protected classes of persons in the Torrance community. Further, that message is another message that discredits the Torrance Police Department in potentially irreparable ways. And again, this message violated several of Torrance Police Department's policies, including but not limited to their anti-harassment policy and several general orders. Accordingly, the division finds that Mr. Satterfield demonstrated bias within the meaning of Penal Code Section 13510.8B5 and 1205A5 when he wrote, "Ah, his little son will grow up without a father now. Oh, wait, that's standard for any African-American family to be absent a father. He'll be fine." The facts that I've just recited support the division's findings that Joshua Satterfield was involved in serious misconduct, specifically demonstrating bias. For purposes of the division's analysis, clear and convincing evidence means evidence of a charge is clear and convincing so long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Joshua Satterfield's post certification be revoked. That concludes my presentation to the board, and to you, I will say that following my presentation to the board, public comment was opened. And I don't recall if any comments were made. I think the attorney spoke. And with that, I'm happy to answer any questions if you have any. Someone's asking if there's public comment after I
Yes, we'll ask for public comment after there are questions from the commission, and then we will, and if there are any comments from the respondent and or his attorney and the commission following that, we'll ask for public comment. Sure. Are there any questions from commissioners? Questions or comments?
Only one, Barcelona, and I mentioned it to a few of the commissioners this morning, is how did this guy get through his background and multiphasic psych without any of this popping up?
Yeah, it's a wonderful question, Mr. Barcelona. I'm not sure. It would be supposition on my part and probably inappropriate, but your comment is noted.
When I was reading through this and, studying it prior to the meeting, I was disgusted, and I felt that he's brought shame onto the profession. But I was thinking about the fact that he had a full background, and you don't just start these type of comments and feelings, once you become a police officer. That had to have been going on for a long time. So why didn't the background pick up any of this? And then why didn't the psychological pick up any of this? And it's just, I know you probably can't answer that, but that really, it really bothers me that especially the background didn't find anything. They should have found something that would have alerted them to this.
Yeah, as stated, I can't answer that, but.
I understand,
yeah.
sir. Thank
Yep.
you.
Commissioner Nieto, I, same sentiments. When I read this case, when I watched the review of the folks before us listening to this case, I was disgusted. I was angry. It made me sad, actually. I think I had nightmares that night because we've worked so hard in this profession to try to eliminate the best we can this kind of stuff. And we have an opportunity today to do that. All the commissioners here, we have that opportunity. But to add to that, it seemed more indicative because there was quite a few officers involved in this WhatsApp, and we only get to see these two officers. And so besides the background issue, what are we doing that we don't create these cultures? And I know we have a lot of training out there, but this seems to be a complete failure on the part of law enforcement and to the communities affected. I apologize. I represent law enforcement as everybody, most people here. And it brings our profession down.
Appreciate the comment. I can't answer one point or bring one point of clarification. You indicate that there were several officers who were involved in this, and just for clarification, these are the two cases that have been brought forward to this point. So.
Thank you, Commissioner. Any other comments from commissioners at this point?
Commissioner
Commissioner
Terry,
Terrio.
when was his lateral transfer from the LA Sheriff's Office? And then I know you said you probably don't know this, but was a full background completed, or is it just a refresher, like a freshen up or something like? Was it actually a complete? Did Torrance do a complete background?
Yeah, I don't have any answers regarding the background
Got it.
specifically. What that may be a root cause of the issue that could probably be looked into. I don't have answers to that, those questions. The first part of your question, when he did the lateral, was 2014. So hopefully
Thank
that, you bet.
Barcelona, may I suggest that when we have cases like this in the future, that you guys delve deeper into it and look into the background or backgrounds of these individuals to see if, where it's coming from, if there's any evidence of it prior, because I think that usually a good background or several backgrounds will, if they're lateraling, there will be some indicators in there somewhere that this type of activity is going to pop up. And I think that it would be really helpful for us on the commission to know the full background, from the back. So if you guys maybe, I know you've got a lot of work and there's a lot of stuff in the hopper for you, and the division it hasn't grown to where it needs to be yet, but I would ask that if you can, to go back and look at their backgrounds to see if there's any indication that points to this, because this is kind of a ongoing problem throughout the state that we see all the time. And you just wonder why it's not getting picked up in backgrounds or in the psychological.
Commissioner Cooper, and that's a good point. Excuse me. For every 100 candidates, you probably might get 4 or 5 out of there in the backgrounds. We do very rigorous background checks, lie detector tests. So it's not that law enforcement's falling on its face on it. It's just a tough issue. And obviously some slip through the cracks, which is unacceptable. But like I said, and it's truth, and the chiefs and sheriffs in here know that. We go through a lot of candidates to try and get the best we can. And obviously it's failing, but for the most part, the folks we get in here are good. So it's tough. I mean, to go back and do that. And hopefully the agency did do a file check, because sometimes some folks don't drive down and actually look at the file. So that would also be interesting to know if they did that.
Yeah, we can certainly take a look into those kind of things. From an investigative standpoint, it's hard to identify what things might become probative at a commission hearing. In this case, I kind of equate that to, a moving violation, then checking what they learned in DMV, in their driver's training. It's at the time, it doesn't it doesn't seem like a direction we would go investigatively, but we can certainly consider that moving forward, and I will take note of that. And on these particular types of cases too, see if we can't find you an answer.
Thank you.
Any additional comments? Commissioner Terrio?
Commissioner Terrio, yeah, I just think it wouldn't, I don't think the goal is to force you to like dig in for the investigative part, but just so you know, at the beginning of your introduction, you gave a history on the officer, et cetera, like something like that to cover those bases. And I think we all understand the legal requirements and what agencies are required to do has changed a lot since then. But so, I mean, that perspective would be great. And then, you know, obviously the absence of, you know, rebuttal is something to take note of as well. But it just would be helpful to have that timeline.
Totally, yeah. I'll take note of that and certainly try and include those in future presentations to you guys.
So Commissioner Nieto, again, I agree with the commissioners here that we need to take a look at that. And maybe there's going to be a pattern that it was the same background investigator or same psychologist who didn't do a good job. But from reading the files, we know that these are just the first two officers involved with many more officers. This is indicative of the Torrance Police Department. So I'm more interested in the culture and is there any training that Post can do, or has Torrance done training? You know, because there's many more officers involved in this just from reading between the lines.
Yeah, what I can say just generally is this occurred some time ago. And from my understanding, there's been significant changes in department culture since that time. But I don't have all the information, so I don't want to put anything forward that would be inaccurate.
Any further comment? I'm not aware that Officer Satterfield or his counsel is present or online, but let's double check. Does Officer Satterfield and or his counsel wish to make any comment at this time?
Mr. Chair, if I may, for the
Yeah,
record.
Mr. Henley.
The Peace Officer Standards Accountability Division did receive an email from Tom Yu, who's the lawyer representing Mr. Satterfield. We received this email on February 24th. He advised that he and his client would not be making any public statements before the commission.
Thank you for the clarification. Is there anyone else who would like to address the commission on this case? I believe I heard Ms. Williamson. Williamson is coming forward. And I'm told we have 4 people online for public comment. For the next case. Welcome again, Ms. Williamson. You have 3 minutes to speak. Thank you for coming forward.
Forgive me, this was very difficult to hear. I am a Black woman and a Black mother. I'm reading a community impact statement for the first half of what I'm going to be speaking about from the communities who were unable to attend today and were directly affected by those officers' misconduct. For the Torrance officer, we call on you to affirm the board's recommendation to decertify Joshua Satterfield and Blake Williams, not only because of the bigoted text message they sent while employed by Torrance PD, but also because both of them, along with several others who also sent bigoted text messages, were involved in the murder of Michael David Lopez. We remind you that the entire Torrance Police Department is now under investigation as a result of their serious misconduct, as it should be, and that all of this came to light because of Sherlyn Haynes, the mother of Christopher DeAndre Mitchell, dared to speak up when Torrance PD killed her only child. Giving either of these individuals their certification back represents a real harm to community, not only the one they have already harmed, but any community they would enter and police in the future. The question is, if you were a Black person, would you want to be pulled over by one of these officers? To have them show up at your house or whatever reason? These individuals represent a continued threat to communities and are clearly anti-Black and racist, in addition to being violent, and for these reasons should have their certification permanently revoked. Doing anything less then decertifying them would be a betrayal of this process and would make the commission responsible for these individuals' actions. This is my statement. Nowhere in Senate Bill 2 does it say determine if there are officers, if these officers are good officers. We need you to determine if they violated Senate Bill 2. Satterfield is a racist officer, and even with the hundreds of hours of police training and continued training, there is no way he should be allowed to continue his bias in communities that look like mine and yours. We are not nigglets or niggers. Satterfield, like many other officers, is not only a disgrace, but he is a criminal. And for far too long, rogue officers are not charged for the crimes they commit. They are simply fired and potentially decertified if they are found to have committed such an egregious violation. Officers moving from police department to department and prosecution officers as investigators. Crazy, because slipping through an application processing crack is injuring members of our community and costing community members' lives. Where there is one racist, there is more. Thank you.
Thank you very, very much, Ms. Williamson. Thank you very much. Mr. Miller, welcome.
Thank you. Yusef Miller, North County Equity and Justice Coalition, Saving Lives in Custody, California. And of course, with the disturbing and disgusting comments from this ex-officer, we find that we don't have the proper tools to identify those people. They just don't exist. This is why they're there. We don't have the proper tools. No matter how hard we've tried, we haven't seen anything that can actually determine, not lie detector tests, not asking people directly. It just doesn't exist. So these people are officers. They're members of the community. We admit that they're members of the community, and the communities have problems. And cultures in certain departments have cultures of racial bigotry and bias. So since these members are a member of the public and the public are officers, we're going to still have these people in the ranks. The community itself has the issues. And the way I know this is because here in San Diego County, we have I'm with the Anti-Hate Crimes Coalition for the county, and anti-Black bias is the highest racial bias in the county. And anti-Semitism is the highest religious bias in the county. And when we see that that's what how we exist, and it shows up on paper that that's the people we're going to recruit when we have that kind of background. And when we see that here locally, and it's like that across the state, when you see here locally that there is empirical data from the stop data of law enforcement, both police and sheriff, that they over-police and overstop people of color during the daytime. The statistics showed that during the daytime, Black and brown are stopped multiple times higher than our white counterparts. But then at night, it balances out. This is an indicator. The data didn't say what that purpose was or what that reason was, but it is an indicator that the observation of the bias of people can be employed here, and it made a difference when that happens. This was a study done on the police department of San Diego County. It was also a study done separately on the sheriff's department of San Diego County. So when we see these issues, we're used to hearing about these issues. We're glad to see that you're willing to decertify a person like that. It does not, it's not the type of person I want to be stopped, or my children be stopped, or my wife to be stopped by this type of person. But we need to be hyper vigilant in determining if we have these people in our ranks currently, which you do. When you have hypervigilance for that and rooting them out before they get to this level of finding them out to a part that people have lost their lives to officers that are patrolling our communities. Thank you.
Thank you, Mr. Miller. Thank you very much for your time and your thoughts. Is there anyone else online who would like to comment at this time about this case? If you could indicate with a call or by raising your hand so that our staff can see if there's anyone that would like to comment. There's not. So at this point, does the commission wish to adjourn into closed session, or is the commission ready to vote? A motion is always in order.
Commissioner Cooper, I move that we adopt the board's recommendation for revocation.
Commissioner Braun, I second.
Mr. Knapp, would you call the roll?
Yes, thank you, Mr. Chair. Barcelona,
Yes.
Barcelona, I. Braun,
Yes.
Braun, I. Brazil.
Aye.
Brazil, I. Cooper,
Aye.
Cooper, I. Doring,
Aye.
Doring, I. Yule,
Aye.
Yule, I. Gordon,
Aye.
Gordon, I. Johnson,
Aye.
Johnson, I. Long,
Aye.
Long, I. Moon,
Aye.
Moon, I. Nieto,
Again, I want to apologize to the communities that we've harmed. Aye.
Nieto, I. Terrio,
Aye.
Terrio, I. Woolry,
Aye.
Woolry, I. Motion passes unanimously with 13 votes.
Thank you, everyone. Thank you for those who appeared. Our next case is Blake Williams and law enforcement consultant Laura Lynn Kong, Professional Conduct, LA County Bureau, and Brian Henley, Post Legal Affairs Bureau, will report on case 2305781. Blake Williams, who at the time of the events at issue in this case was employed with the Torrance Police Department. This recommendation by the board was also a unanimous vote to revoke. Ms. Kong, Mr. Henley, all yours.
Good morning. Let me make this for a short person. My name is Laura Lynn Kong. I'm a law enforcement consultant. I'm assigned to the Professional Conduct Los Angeles Bureau County in the Professional Conduct Bureau. I'm here with respect to the case of post 2305781 involving Officer Blake Williams and the Torrance Police Department. I'm here with Bryant Henley, an attorney with the Legal Affairs Bureau. In this case, the division found reasonable grounds to believe that Officer Williams engaged in serious misconduct in violation of Penal Code Section 13510.8, specifically Penal Code Section 13510.8B5 and Regulation 1205A5, demonstrating bias. These violations occurred when Officer Williams sent and/or responded to 6 text messages via the WhatsApp group chat text titled "The Boys" that displayed prejudice, intolerance, and/or hatred towards protected classes of persons that would lead a reasonable person to conclude that the officer has not fairly and impartially performed or will not fairly and impartially perform their law enforcement duties. These messages occurred between July 18, 2018 and September 2019, but were discovered in 2022 as a result of a separate criminal investigation of 2 other officers who were members of the WhatsApp group chat. In the division's investigative summary and findings, is recommended that the revocation of Officer Blake Williams' post-certification. In accordance with the requirements of Senate Bill 2 and as required by Penal Code Section 13510.85A4, this matter was heard by the Peace Officer Standards Accountability Advisory Board on January 16, 2025. Following the conclusion of that hearing, the board voted to recommend the revocation of Mr. Williams' post-certification. The division asked that you adopt that recommendation today. As required by Penal Code Section 13510.85A5, the record of that proceeding is before you, which includes the agenda and attachments from that meeting, a transcript of the relevant portions of the hearing, and the recommendations of the board. The law requires your review to be of that record before the board, which is before you and which you have had an opportunity to review. To assist you in your review of the record, I will take you through the case presented there. As the record shows, I presented the case before the board substantially as follows. Blake Williams began his career with the Torrance Police Department on June 9, 2016 as an officer. Mr. Williams holds Post Basic Certificate, which was issued on June 12, 2017. On April 4th, 2023, the Torrance Police Department reported allegations of serious misconduct by Mr. Williams to Post pursuant to California Penal Code Section 13510.9A3. The allegations stemmed from a January 2002 criminal investigation of 2 Torrance police officers, which resulted in the discovery of racist, homophobic, and anti-Semitic text that had been sent between members of the Torrance Police Department, including Mr. Williams, between July 2018 and September 2019. Based on this information, the Torrance Police Department conducted an administrative investigation into several officers in the department, one being Mr. Williams. The sustained investigation found Mr. Williams received, sent, and/or responded to while on and off duty text messages that were determined to violate several of the department's policies, including but not limited to the prohibited acts that brought discredit to the department and prohibited bias-based policing. The department considered the discriminatory text messages grounds for termination. Mr. Williams was terminated on March 15, 2023 for policy violations related to the discriminatory text messaging and for policy violations unrelated to the discriminatory text messages. Mr. Williams has appealed his termination with the City of Torrance. 6 of these messages were described in detail within the investigative summary and findings, attachment A, and the transcripts of the presentation to the board in January. I will now present a PowerPoint which shows the 6 messages that are subject of today's serious misconduct action. Please be advised, the content I'm about to show is offensive. It's offensive material, and I'll try to get through this to not belabor it. Next slide. On July 4th, 2018, in a WhatsApp message to the boys group, Mr. Williams mentions Officer Chandler needing to get off probation. Officer Chandler responds, "I'll eat sweaty ass at this point with dingleberries." Next slide. Mr. Williams is respondent. Mr. Williams replied with an image of a male adult in blackface. His post reads, "I Googled dingleberry and this popped up. Way funnier." Next slide. On July 5th, 2018, Mr. Williams sent a WhatsApp group message to the boys. The message contained an image of 2 muscular black males wrestling or fighting. Mr. Williams' captioned message was, "Hey, young, every day you don't work out, just know some gorilla-looking F-word is getting it in over you in the Shadowlands." Young is believed to be a Torrance police officer, Young, and a member of the boys group chat. Next slide. On August 23rd, 2018, one of the messages to the boys mentioned Omar, who is believed to be the Torrance Police Department officer Omar Alonzo, who is one of the members of the text group. The message string began with Mr. Williams. "Omar was, though." Officer Satterfield responded, "I'll Superman punch Omar on the run and then just keep going and see if they chase me." Mr. Williams replied, "Bro, not a good idea. The big brown war machine would not be pleased. Generations of field work has left his knees numb and calloused." Mr. Williams further replied, "Omar's people excel at fence hopping." Next slide. On November 4th, 2018, members of the boys group chat were discussing the types of inappropriate content that might be found on other Torrance Police Department officers' social media accounts. A text message from Officer Chandler to the boys' WhatsApp group read, "Dude, you have no idea. I'm literally on fire right now. I can't believe we hired a racist cock like this. Don't we check Facebook and shit? WTF is this?" Shortly after, next slide, Mr. Williams sent a message that contained the image of a scene of a lynching. And he commented, "They missed this on mine." Another officer responded, "Jesus, Blake, ha. That's history, though. There's knowledge in that." Shortly after that message, Mr. Williams sent another message, "Hanging with the homies." Next slide. On November 8, 2018, Mr. Williams engaged in messaging within the WhatsApp boys message string when the group had been discussing the department's hiring of new officers. Officer Dempsey posted, "Hiring staff is picking some real winners." Officer Satterfield responds, "It's okay. Once Rhea gets up there, he's about to hire some pipe hitters." Mr. Williams commented, "Wait, did we hire a faggot, a fagola?" Next slide. On March 27, 2019, Mr. Williams sent a WhatsApp message to the group containing an image of a smiling cartoon animal. In this caption, he says, "When you fart next to a Jewish kid, you realize you gassed the Jews." The division finds with a high degree of probability that Mr. Williams demonstrated bias within the meaning of Penal Code Section 13510.8B5 and Regulation 1205A5 when Mr. Williams sent and/or responded to these 6 discriminatory messages, and that these messages showed prejudice, intolerance, and hatred based on a person's race, religion, and sexual orientation. Race, religion, and sexual orientation are all protected classes of persons identified in Penal Code Section 13510.8B5. Additionally, the division finds that Mr. Williams demonstrated bias within the meaning of Penal Code 13510.8B5 and Regulation 1205A5 when Mr. Williams sent and/or responded to the text messages and photographs I presented to you. Mr. Williams' acts of texting messages and photographs and/or responding to messages would lead a reasonable person to conclude that the officer will not fairly and impartially perform his law enforcement duties. Based on the facts of this case, as described here, and in the investigative summary and findings, there's clear and convincing evidence that Mr. Williams demonstrated bias. Therefore, the recommendation is that Mr. Williams' peace officer certification be revoked. Following my presentation to the board, and as documented in the transcripts before you, public comments were made by Mr. Williams' counsel as reflected in the transcripts. Also, a member of the public, Mr. Sanchez, called in to the meeting and he appreciated the work that was being done because of SB2. His comments are also reflected in the board transcripts that you've received. The board did not go into closed session. The board voted to recommend revocation of Mr. Williams' certification. 7 board members were in favor and 1 member reclused herself for the motion to recommend revocation. Sorry. If the commission has any questions, Bryant and I will be happy to answer them.
Before we go to Mr. Williams, attorney, who I believe is online, are there any, and you'll have, commissioners will have an opportunity, of course, to ask questions there. Are there any comments or questions from the commissioners at this point? We will say, does Officer William or his counsel wish to comment?
Good afternoon, or excuse me, good morning. Corey Glaive on behalf of Officer Williams.
Mr. Glaves, just one moment, please. As I read the admonition here, you will have 5 minutes to speak. Time limits will be enforced. Keep in mind the commission can only consider facts presented by the division today and will not consider additional facts, mitigating factors, or defenses at this time. The only question before the commission today is, do the facts offered by the division today, if proven at a later evidentiary hearing before an ALJ, demonstrate high probability that serious misconduct defined in Penal Code Section 13510.8 and Commission Reg 1205 took place? Mr. Glaze, floor is yours.
Thank you very much, and I appreciate the opportunities to speak to you. First, this action to decertify my client is based on acts that are alleged to occur in 2018 and 19, well before the laws enacted and post regulations were drafted and modified, and post keeps modifying them. Under due process, an officer must be given notice of what conduct can serve as decertification, and no such notice was provided here. And there's no evidence that anything happened. The latest was one message in 2019 and nothing since. There's also an equal protection issue, as there was 18 officers involved in the purported message thread, and you're only right now seeking to decertify 2. You've had them both here today. Moreover, other officers, because they're being prosecuted criminally and gave rise to these findings, or to the discovery of messages, which you don't actually have copies of the messages, you have summaries of them. They're not subject to decertification because they were terminated in 2020. In 2020, the Torrance Police Department found these messages. They found all the messages. Their administration decided that the messages did not violate policy by the other officers, nor were they misconduct. It wasn't until later, when District Attorney Gascon and his administration saw the messages, that they raised the issue of, oh my goodness, these must be racist, without any context whatsoever. So you have due process and equal protection issues going forward. And as post trains, every person
Mr.
has.
Glaze, could you pause for just a moment here? I'd like to check with our attorney. I think we're getting a little bit far afield from the evidence that was presented by the division today. I'd like to ask our attorney to be more specific.
Yeah, just a healthy reminder that the, issues raised in the investigation summary and findings are the restriction as to the commission's ability to review. So things like, Mr. Gascon's input on this case is certainly external to that report, unless counsel can point me to that. I did not see that in the investigation report. So I think we really want to kind of restrict ourselves to that set of issues and facts.
Well, if you're using if you're using a 2022 discovery date, was the discovery by Mr. Gascon's office, not the Torrance Police Department. They discovered them in 2020 and took no action because they did not believe it was a policy violation at that time. As post trains, everyone has bias. And that's why one of the decertification panelists had to recuse herself, because she had her own personal bias. It's only a problem when in your official capacity, you act on that bias. And there is no evidence before this commission, this board, that any action by my client demonstrated bias in his profession. In fact, if you look at his personnel file, it's quite the opposite. He's been a solid officer with good evaluations, numerous awards, life-saving measures without regard to race, gender, religion. We still contend the evidence was obtained unlawfully from invalid warrants, and you're receiving just summaries about that. However, when you look at the messages, you cannot insinuate bias when you have clearly just responses and maybe at worst improper jokes from 2018 and 19. Supposition as to my client's motives does not constitute facts, and clearly not clear and convincing evidence of that. Torrance Police Department looked into all the actions of my officer during that time period and found no evidence of bias in any official performance of his duties. There's simply no evidence my client ever acted with bias in his chosen profession and official acts. Moreover, the post regulations keep changing and are being modified to see what's included therein. That's not fair to an officer to say, back in 2018, and you continue to be an officer, you never engaged in any other acts demonstrate bias. There should be some act, some indication that my client has bias and acted on it as a police officer. That didn't occur in this case. There is no bias. You look at the messages. The first one is in response to the word dingleberry. It's not a racist post. The photograph has been attributed, when used improperly, to be racist. The second one, about two people wrestling. I see these posters throughout California police departments of warning officers, you need to be fit because this is what you're going to have to fight. And it doesn't matter whether they're the suspects, race, anything else. If they're more fit than officers, you train the officer to be fit. The third one was concerned that the department was hiring racists based on what that new hire Facebook looked like, and officers knew about it. It wasn't supporting the hiring of a racist, it was opposing it. All you have to do is look at the messages there. The fifth one is a joke based on what his partner had said to him. His partner was Jewish and made the joke, and they made a post about it. It wasn't meant to be offensive. It was simply officers making jokes about each other, not about citizens, not about the public. All these things deal with internal humor, whether it's inappropriate or not. That's what it dealt with. There's no demonstration of bias. Thank you.
Hello. Thank you, Mr. Glaive. Other comments from the commission, and we'll ask for comments from Mr. Henley. Any comments or questions? Commissioner Gordon?
I just have one comment, no questions. To categorize this as just inappropriate humor is quite insulting to me and to our profession. And I want to reiterate my apologies to our communities and to our profession for this. I did not expect to have I read it, I reviewed all of it, but in this moment, having a almost visceral reaction to this and knowing that this is continuing within our profession is tragic. So.
Thank you, Commissioner. Commissioner Barcelona?
I just want to echo her comments. One I thought was particularly appalling was the lynched I think it was two black men, and the comment of hanging with the homies. I thought it just infuriates me that a police officer would post that, or if you got it, would comment on it, other than saying, don't send me this anymore. But, to categorize it as not offensive or not racist is BS.
Commissioner Terrio?
Commissioner Terrio, just a comment. No question. I don't disagree with counsel that due process is extremely important, and perhaps there are issues on due process, and it's one of the more fundamental issues in our country, is in our justice system and jurisprudence. However, I can say as someone who travels state of California and go to a lot of police departments, I can tell you, I look around on the walls and I never see any photos or anything about, two black men wrestling each other, talking about, duking it out in the Shadowlands, whatever that is. So I don't know what you're talking about when you reference other police departments, and I think that's disparaging. And then to Commissioner Barcelona's point, the photo of hanging with the homies refers to an area and time in this country which is most definitely painful for minorities in this country. And I think it's outrageous to think that there's no, bad intent on that. But that is you're entitled to that opinion, but I disagree. And I think it speaks volumes as a peace officer that would be acceptable. Thank you.
Thank you, sir.
Commissioner Nieto, I've already said my comments, but this is a different comment. The reason behind SB2 is to bring to light things that agencies may or may not have done. And that's why we have different reporting systems for SB2. And so the fact that Torrance didn't find it misconduct back whenever they did, as a commissioner, I know we're a separate board and we have a separate responsibility to make a decision.
Thank you, Commissioner.
Commissioner Cooper, it doesn't matter when it was found out or when it occurred. The bottom line, this has no place in law enforcement. It's a black eye for everyone, racist. I've never seen anything like that in my life, other than going back in history, and to have it bannered about as just, commonplace is truly disturbing, And I agree with Commissioner Nieto. That's why SB2 was here, to weed out the bad ones. And that's ultimately what it comes down to. We don't need this in law enforcement.
Commissioner Braun. I am saddened and offended by the existence of this chat group. And to say that everybody has their own biases, and we know that when we're not supposed to act upon them. The very existence of this chat group with other officers is acting on those biases and reinforcing those biases with your chat group. It is beyond the pale and it will not be tolerated.
Any further comments? Before we move on, Mr. Glaves, does your client wish to comment? I'm getting different reports that he's online. I don't know if he's just watching or if he wanted to comment.
He is online, but he won't be commenting.
Thank you, sir.
Mr. Chair, if
Mr.
on
Henry.
behalf of the division, I would like to respond briefly.
Please.
Thank you. And commissioners have already really addressed a lot of the points that I don't want to belabor, especially given the painful nature of what has been advocated and the subjects discussed. I would like to focus on some of the legal arguments that have been brought to you today, because it's important, I think, to establish responses to those in the record. So I want to first start with the arguments by Mr. Glaive that somehow, because these incidents took place in 2018 and 2019, they're not appropriate for this commission to consider. And that's simply not what Senate Bill 2 says. Senate Bill 2 says that it's Penal Code Section 13510.8 G1A. If there has not been a final determination until after SB2 on an investigation, that would give jurisdiction to this commission to investigate those acts. And in fact, that's exactly what happened here. The city of Torrance concluded its investigation long after SB2 took effect, not before. And while Mr. Glaive is certainly welcome to make further arguments if this commission votes to have an administrative law judge hearing and can present those, we are highly confident that this case is well within the jurisdiction of this commission to be heard and to take action. Secondly, one point, this is a point that Mr. Glaive had attempted to argue before the board and has now argued again before you. Because these are the first bias cases we've heard, it's important, I think, to emphasize this. There have been arguments presented to you that somehow, in order to constitute serious misconduct, there must be a quote unquote act, not just the words, but then some secondary act to demonstrate that bias. Thankfully, the legislature did not see fit to require an act to get to bias. That's not the standard. I want to emphasize that again. The standard is very clear, both in the penal code and in the regulations that were adopted to clarify existing law. It's a restatement of existing law, those regulations. But whether we're talking about the statute that SB2 and the legislature adopted or the regulations that followed under either standard, the question before this commission is, were these words, would these acts and conduct, would the words, not the acts, excuse me, would they lead a reasonable person to believe that that peace officer cannot or will not fairly and impartially perform that officer's duties within the Torrance community? And I think there is really no question here, and I won't belabor the point, but there is no question that the words are more than sufficient for a reasonable person to conclude that Officer Williams would not fairly and impartially enforce those duties. So again, it is not the matter of acts, it's the words. That's sufficient if a reasonable member of the community would conclude that person would not fairly and impartially perform their duties. even though acts are not required, and Commissioner Gordon and others touched upon this, I would also like to point out that unfortunately and sadly, there were some acts conducted by members of this 15-member group, the WhatsApp The Boys group. 2 of those individuals that are among the 15 members are currently facing criminal charges because one of them has allegedly painted a swastika on the car of a member of the Torrance community and currently is facing criminal charges because of that. And so to the extent we've heard suggestions today that these were jokes, these were not meant to be furthering bias, et cetera, I would respectfully submit that the facts that we've already heard belie any absurd suggestion. And with that, I really don't think that I want to get into any further debates here, unless, of course, this commission has legal questions of me. There was one other point about equal protection, the suggestion that because only 2 peace officers today from Torrance, their cases are before you, that somehow that's an unfair or unequal aspect of how these cases are being brought. And to be sure, we will see if there are further Torrance cases brought. I think you will find there will be other cases besides this one. That is not an equal protection violation. And it's an argument that Mr. Glaive is welcome to make before an administrative law judge, but it will fail. With that, I will make no further comment unless, of course, Mr. Chair or commission members, you have questions of the division, in which case I'd be happy to respond to those.
Thank you, Mr. Henley. Questions for our counsel? Comments? Would anyone else who is here would like care to address the commission? Please come forward. See Ms. Williamson. You have 3 minutes to speak. Welcome. Thank you for your time.
It is certain in any case that ignorance allied with power is the most ferocious enemy justice can have. James Baldwin. Officer Joshua Williams is an enemy to justice, and continuing his certification would align with conspiring to accept egregious racism. The community deserves to have equal protections from racist law enforcement officers. These improper jokes are not just a mishap. They are offensive to me and to my community. My people were strange fruit hanging from trees, bodies often mutilated, and it is called lynching, not hanging. Officer Joseph Williams since 2016 and decertified Officer Satterfield since 2014 were allowed to remain on the force comfortably and are alleged to have terrorized community members in the city of Torrance. Community members too afraid to come forward because of retaliation. It is up to all of us, Black, white, everyone, no matter how well-meaning we think we might be, to do honest, uncomfortable work of rooting it out. Michelle Obama, thank you.
Thank you, Ms. Williamson. Mr. Miller, welcome.
Yusef Miller, North County Equity and Justice Coalition, Saving Lives in Custody, California. And this case is disturbing on so many additional levels. It's a wide swath of bias that impacts everybody and anyone that has any sense of decency. And to try to justify it in these weak attempts to dismiss the vileness of these actions and these statements. A statement and a response are actions. So they might not be actions to the law, but they're actions to us, actions to people who are impacted by those things. The idea that they will put up a black face or someone who has been lynched, these are the pictures that we show our children about how far we've come in this nation to be where that can't happen easily anymore. These are the pictures we teach our children, and our children are aghast. Whether you're black a child or a brown child or a white child, those children are aghast at this. And we say from a higher standard of law enforcement that this should be far removed from them. This is the post, standards and training. And this should be high removed from them. Yet we have this case here. And thank you for, I can tell the sense of where we're going with this, but I think I was enraged by the attempt to defend such statements that I was racist before SB2, therefore it's not applicable because I was racist before SB2. This is not a issue of that, because if it was not against policy before SB2, it should have been. And it still should fall under unbecoming, conduct unbecoming of an officer. Now, if I was to know about these things and I lived in Torrance, I would be afraid to be pulled over by law enforcement, to be stopped by law enforcement, to be even helped by law enforcement, because that would signal that I'm in close contact with someone who does not value my life. We need these laws. That's why they exist, SB 2 and other laws like that. The people were hanging in those pictures died for the 14th Amendment. They fought for the 14th Amendment. And to have the 14th Amendment brought up in defense of this race. So Dr. Martin Luther King said that laws cannot change the heart, but it can protect you from the heartless.
Thank you, Mr. Williams. Are there any, I don't believe there's anyone online wishing to comment, correct?
Mr. Chair, I
Yes.
move that we adopt the board's recommendation for revocation.
Commissioner Gordon, I second.
Jen, would you call the roll? Mr.
Thank you,
Knapp,
Mr.
please call the roll.
Barcelona,
Yes.
Barcelona, I. Braun,
Yes.
Braun, I. Brazil.
Aye.
Brazil, I. Cooper.
Aye.
Cooper, I. Doring.
Aye.
Doring, I. Yule.
Aye.
Yule, I. Gordon.
Yes.
Gordon, I. Johnson.
Aye.
Johnson, I. Long.
Aye.
Long, I. Moon.
Aye.
Moon, I. Nieto.
Aye.
Nieto, I. Terrio.
Yes.
Terrio, I. Woolry. Woolry, I. Mr. Chair, the motion carries unanimously.
Thank you, Mr. Knapp. All right. Connie, I'm guessing a break is in order. All right, it's 10:15. Why don't we take 15-minute break back at 10:30 prompt, please, for our final case. All right, I see almost everyone is back in their chair. You guys ready?
You. I'm gonna go back. My bags are back there. I'm gonna go back. change.
Our final case of the day. Braulio Robledo, law enforcement consultant, Robbie Bringolf, professional conduct, LA County Bureau, and Carrie Woolley, attorney from Post Legal Affairs Legal Bureau, will report on case 230-9558, Braulio Robledo, who at the time of the events of this case was employed by the LA County Sheriff's Department. The board recommendation to the commission was revocation by a vote of 7-1. Mr. Bringolf, Ms. Woolley, please.
Thank you, Chair Long. Just a little caveat before we start, a disclaimer. This case was originally investigated by LEC Mark Evenson. He retired from Post and moved on. So this was adopted by me kind of to get it into the net and present in front of you guys. So there may be some questions. This may present a little bit differently as we go through this case. Ms. Woolley may ultimately answer some of the questions that you might direct towards me because she has intimate knowledge of the case and had worked with Mr. Evenson throughout the investigation. That said, in this case, the division found reasonable grounds to believe that Deputy Robledo engaged in serious misconduct in violation of Penal Code Section 13510.8B1, alleging that Mr. Robledo was dishonest when being investigated by Internal Affairs for an allegation of theft during a traffic stop. In our investigation of the division and in our summary and findings, we recommended revocation of Mr. Robledo's post certification. This matter was heard by the Peace Officer Standards Accountability Advisory Board in January of this year. And following the conclusion of that hearing, the board voted to revoke Mr. Robledo's certificate. And we ask you to adopt that recommendation today. Deputy Robledo was hired by the Los Angeles County Sheriff's Department on March 11th, 2005. He was terminated from LA County Sheriff's Department on August 2nd, 2024. PC Section 13510.8C5, that's Penal Code section, provides that the commission shall consider the peace officer's prior conduct and service record and any instances of misconduct, including any incidents occurring beyond the time limitation for investigation, and evaluating whether to revoke certification for the incident under investigation. As such, we took a look at history and we found that respondent has a prior sustained finding for dishonesty. On April 11th, 2023, the LA County Sheriff's Department found that the respondent violated department policy and procedures. Let's see. In investigation to spending about 40 minutes socializing with 3 females while on duty in a secluded dark parking lot and having a conversation which was personal in nature with one of the females, and admitting to using the mobile data computer to conduct a quote wanted persons check on one of the women's ex-husband to verify if there's a restraining order. Some other violations of policy for making false statements during departmental internal investigations. During his administrative interview with the Internal Affairs Bureau, respondent contradicted his unit history report by stating he didn't run the name of one of his female companions on his mobile data computer on the night in question. The preponderance of evidence supported that the respondent did run the female's name on his MDC and lied about it in his IA interview. For that, he received a 30-day suspension. The agency reported that case to us at Post on April 25th, 2023 as a possible violation of Post Regulation 1205A1, which is dishonesty. Should it become probative, that Post case number was Post 2306952. On November 9th, 2023, Post closed the case with a status of no further action, or NFA as we call it, because the conduct did not meet the clear and convincing standard for serious misconduct as defined in PC Section 13510.8. On October 19th, 2021, the LA Sheriff's Undersheriff conducted an audit of misconduct investigations and found that respondent had 2 separate investigations, one in 2018 and one in 2019, where fellow deputies alleged he was a member of a law enforcement gang called the Banditos. Each incident involved a different deputy making the allegation. Based on that information, the Undersheriff directed the agency to conduct an administrative investigation into the allegations. That agency investigation failed to substantiate the allegations and was closed on July 19th, 2024 as unresolved. The agency reported that case to Post on May 25th, 2023 as a possible violation of Post Regulation 1205A7, which is participation in a law enforcement gang. And on October 8th, 2024, we closed the case with the status of NFA or no further action because there was no evidence presented to support the allegation that the respondent was a member of a law enforcement gang. Which brings us to the present allegations of serious misconduct. A citizen called the Los Angeles County Sheriff's Department East Los Angeles Station and stated he had been stopped by an unknown officer in the early morning of January 2nd, 2020, immediately after leaving the Commerce Casino. During the stop, the citizen alleged that the officer searched his vehicle and stole 5 poker chips worth $100 each. When asked directly by his supervisors, who were a sergeant and a lieutenant, if he made a traffic stop in front of the Commerce Casino, respondent adamantly stated he did not. The Los Angeles County Sheriff's Department submitted this case to Post, in which they alleged Deputy Braulio Robledo was involved in serious misconduct when he lied to his supervisors and lied during an internal affairs investigation regarding the previously mentioned citizen's complaint that the respondent conducted a traffic stop in front of the Commerce Casino and during a search of the vehicle stole $500 in poker chips. After reviewing that investigation, the division has determined respondent committed serious misconduct as defined in PC Section 13510.8B1 and California Regulation 1205A1. Those are our dishonesty regulations and laws. The respondent committed serious misconduct when he lied to his supervisors, when he denied any knowledge of a traffic stop that he clearly conducted just a few hours earlier, and he lied during his IA interviews when he claimed his supervisors never asked him about the specific traffic stop near the Commerce Casino. Deputy Robledo claimed he received information that supervisors were inquiring about a stop that occurred in Montebello. Deputy Robledo claimed he deleted the MDC messages sent by the watch sergeant without reading them, and he claimed he never responded to the sergeant's MDC messages inquiring who made the stop. Deputy Robledo claimed he had no knowledge of why the watch sergeant was trying to get a hold of him, and he denied he called the East LA Sheriff's Station and spoke to Deputy Strelo about the traffic stop in front of the Commerce Casino. The evidence overwhelmingly supports respondent did stop the complainant at Telegraph Road and Washington Boulevard and lied to his supervisors about the traffic stop. The evidence also overwhelmingly supports that respondent lied to IA investigators during the IA interviews. While investigating a citizen's complaint alleging that an unknown officer or deputy stole $500 worth of poker chips during a traffic stop, supervisors asked respondent if he had stopped the complainant around the Commerce Casino. The respondent adamantly denied he was the one who stopped the vehicle. This conversation took place approximately 3 hours after the time of the traffic stop. There's indisputable evidence that respondent was the one who conducted the traffic stop. This evidence included a unit history report showing that the respondent ran the complainant's license plate, a GPS tracking report showing respondent stopped his vehicle at the exact time and exact location alleged by the complainant, and video surveillance footage confirming that it was the respondent's patrol car making the traffic stop. The respondent later admitted to making the traffic stop during his IA interviews. Respondent claims supervisors never specifically asked him about the stop in front of the Commerce Casino and assumed they were asking him about a stop that occurred in Montebello. These statements are also refuted by clear and convincing evidence. The respondent lied to IA investigators when he stated he did not know his supervisors were asking about a traffic stop that occurred in front of the Commerce Casino. During his IA interviews, respondent tried to claim that he had no idea his supervisors were asking him about the traffic stop in front of the Commerce Casino. The evidence supports that this is a false statement. Both the watch commander and the watch sergeant made it abundantly clear that they were inquiring about the specific stop that occurred in front of the Commerce Casino, and there was no question respondent understood which stop they were referring to. There is no reason why the watch commander and watch sergeant would lie in their statements, and their statements are more credible than the respondent's. The respondent received 2 MDC or mobile data computer messages from the watch sergeant inquiring about a traffic stop in front of the Commerce Casino around Washington Boulevard and Telegraph Road. The first MDC message was sent to the 3 deputies working the City of Commerce to include the respondent, and it stated, "Did any of you stop the complainant at Washington and Telegraph earlier?" 2 other deputies immediately replied, but the respondent did not respond. So he was then sent a direct MDC message, and it stated, "Did you pull over the complainant at Washington and Telegraph a few hours ago?" Again, the respondent did not answer the question, but approximately 12 minutes after receiving the second MDC message, respondent sent the watch sergeant an MDC message stating, "Called you, Sarge." This provides clear and convincing evidence that the respondent did receive the message and was fully aware of what traffic stop his supervisors were inquiring about. The respondent's refusal to answer the sergeant's MDC messages supports the conclusion that respondent was being deceitful in trying to hide the fact that he was the one who stopped the complainant in front of the Commerce Casino. Respondent's claim that he had no idea what traffic stop his supervisors were asking him about is further refuted by the fact that approximately 35 minutes prior to meeting with his supervisors, respondent called the East LA station and spoke to Deputy Strelo on a recorded line. Deputy Strelo told respondent that the watch sergeant was inquiring about a stop in front of the Commerce Casino. This provides clear and convincing evidence that respondent knew exactly what traffic stop he was being asked about during his meeting with supervisors. Respondent's claim during his second IA interview that he did not remember the conversation with Deputy Strelo is not believable, particularly as respondent was able to provide details about a conversation he claimed to have with Deputy Palacios earlier during that same shift about a different stop, allegedly in Montebello. The respondent also lied to IA investigators when he stated he received information that supervisors were inquiring about a traffic stop that occurred in Montebello. During his IA interviews, respondent tried to claim that he didn't lie to his supervisors because he thought they were asking him about a stop that occurred in Montebello. It's already been established that based on the supervisor's testimony, the MDC messages, and respondent's phone conversation with Deputy Strelo, respondent knew his supervisors were inquiring about a stop in front of the Commerce Casino. When asked by IA investigators why he thought they were talking about a stop in Montebello, respondent stated he received 1 or 2 MDC messages inquiring about a Montebello stop. He also claimed that he called Deputy Manuel Palacios on his cell phone, and Palacios told him that someone was calling in about a stop in Montebello. Respondent's statements are refuted by indisputable facts. One, there's no record of any MDC messages being sent out about a stop that occurred in Montebello. Two, when Deputy Palacios was interviewed, he stated he had no recollection of a phone conversation with respondent. There's clear and convincing evidence to support the conclusion that respondent created a narrative about a fictitious Montebello traffic stop to cover up the fact that he lied to his supervisors and disingenuously claimed to IA investigators that his previous denial to his supervisors did not constitute dishonesty because he allegedly believed they were asking him about a stop in Montebello. However, the clear and convincing evidence shows that respondent lied to IA investigators when he claimed he received MDC messages about a Montebello stop, and when he later claimed that Deputy Palacios gave him information about a Montebello traffic stop. Outside of the respondent, no one else had any knowledge of an alleged traffic stop in Montebello. The respondent also lied to IA investigators when he stated he was not aware the watch sergeant was trying to contact him. The respondent told IA investigators that he was not aware that the watch sergeant was trying to contact him, and that statement is refuted by indisputable facts. One, respondent sent an MDC message to the watch sergeant that said, "Called you, Sarge," and that message was sent approximately 12 minutes after respondent received a direct MDC message from the watch sergeant asking if he had recently stopped the complainant in front of the Commerce Casino. Two, during his recorded conversation with Deputy Strelo, respondent stated he and the other Commerce units received a text from the watch sergeant. This provides clear and convincing evidence that respondent lied when he said he was not aware that the watch sergeant was trying to contact him. In another instance, the respondent lied to IA investigators when he stated he deleted the MDC messages from the watch sergeant without reading them. The evidence proves that respondent did read the MDC messages from the watch sergeant. One, approximately 12 minutes after receiving the watch sergeant's second MDC messages, he called that sergeant and sent the message, "Called you, Sarge." And two, during his recorded conversation with Strelo, respondent told Strelo that he and the other Commerce units received a text from the watch sergeant. This provides clear and convincing evidence that respondent lied to IA investigators when he stated he deleted the sergeant's MDC messages without reading them. The respondent also lied to IA investigators when he stated he never responded to any of the sergeant's MDC messages. Approximately 12 minutes after the watch sergeant's second MDC message, the respondent replied via MDC stating, "Called you, Sarge." This provides clear and convincing evidence that respondent lied when he stated he never responded to any of the sergeant's MDC messages. The respondent lied to IA investigators when he stated he never called the East LA station and spoke to a deputy on a recorded line regarding a traffic stop in front of the Commerce Casino. During his first IA interview, respondent was repeatedly asked by IA investigators if he called the East LA station that morning and spoke to a deputy, including whether he spoke to a deputy on a recorded line, and each time he responded with, "No, sir." These denials are refuted by the fact that there is a recorded phone conversation proving that respondent did call the East LA station and received information that the watch sergeant was inquiring about a traffic stop in front of the Commerce Casino. This provides clear and convincing evidence that the respondent lied to IA investigators. The respondent attempted to explain away his prior denials during his second IA interview after the IA investigator played the recording by claiming that he did not recall the conversation. However, respondent's claim is not credible, particularly given his clear recollection of the details of the stop at issue, including but not limited to such details as to whether he lifted the backpack, whether the backpack looked like it could have contained a weapon, and his clear recollection of his conversation with Deputy Palacios, which respondent repeatedly cited as his explanation for why he thought his supervisors were asking him about a stop in Montebello. The evidence is thus clear and convincing that respondent lied to IA investigators when he denied calling into the East LA station. The facts that I've just recited support the division's finding that Braulio Robledo was involved in serious misconduct, specifically dishonesty. For purposes of our analysis in the division, clear and convincing evidence means evidence of a charge is clear and convincing as long as there is a high probability that the charge is true. The evidence need not establish a fact beyond a reasonable doubt. The division recommends that Mr. Robledo's post certificates be revoked. The division's recommendations based on the clear and convincing evidence that respondent lied to his supervisors about the traffic stop and subsequently repeatedly lied during his IA interviews. The facts fully support respondent knew exactly which traffic stop his supervisors were inquiring about and lied to them about his involvement. In addition, respondent lied several times during his IA interviews when he, one, stated his supervisors never asked him specifically about the traffic stop he conducted in front of the Commerce Casino. Two, stated he was not aware that the watch sergeant was trying to contact him. Three, stated he deleted the MDC messages from the watch sergeant without reading them. Four, stated he never responded to any of the watch sergeant's MDC messages. Five, stated he received MDC messages about a stop in Montebello. Six, stated he was told by Deputy Palacios that there was an inquiry being made about a stop that occurred in Montebello. Seven, stated he did not call and speak to Deputy Strelo. And finally, eight, stated that no one gave him information that the watch sergeant was inquiring about a stop that occurred in front of the Commerce Casino. Following my presentation and Carrie's presentation to the board, public comment was opened up. At that point, we're happy to answer any questions you might have.
Thank you, Mr. Ringolf. Before we ask if the respondent officer or his counsel is present and would like to comment, are there any comments or questions from the commissioners of Mr. Ringolf?
Sure. I realize it's not your work product, so take some of my statements and into context with that. I'm concerned, I have a lot of concerns on this investigation, and I'll start off by stating why is there additional information that was investigated by Post found not to meet the clear and convincing standard and put into the executive summary. Each one of these cases should be able to stand on its own 2 feet. It's not necessary to add things that were clearly investigated by the agency. They found their findings, but then they were investigated by Post and found not meet the evidence standard. I don't need to know about them. Then it's not germane to the specific issue. And I find it almost prejudicial, like it's trying to put the thumb on the scale and tilt it one direction or the other, when each case should be able to stand on its own 2 feet without that information. Secondly, someone who works in a black and white quite frequently still, despite my position, including just this past week, MDCs and whether people read them and what messages they get. It's easy to hit delete, not look at a message, or easy to turn off your MDC and you wouldn't read them and you wouldn't know them. Just because the signal has been sent to the car or the MDC does not constitute acknowledgement. And I think that would be pretty much impossible to prove. So I have some issues with the investigation on that. And then it kind of starts to kind of erode the what the investigator comes up as the stated facts that are clear and convincing at the end. I think there's definitely some issues about what was known when by the deputy on the stop, and whether the traffic stop and what he said, especially with the thing with the recorded line. The issues about MDC, it's almost like, how far did Post, I guess, go into, did the investigations division go into some of those claims and understanding that? Because again, just as someone who works the street can tell you that, you're not, how are they going to know what MDC messages he saw? It's impossible. So that raises flags for me immediately.
Sure. I appreciate the indicating it's not my work product, but as the division's work product. So I'd like to an opportunity to respond. Section 1213 allows us and sort of compels us to take a look at an officer's previous work history. So not mentioning any of those things, I think, would be inappropriate. We did mention them not to prejudice the case, but to show that we did investigate them and that they did not meet the evidentiary standard that Post needs. They did meet an evidentiary standard that the agency needed, and those things differ. And I think it's appropriate to mention those things, but I appreciate your position. As far as the MDC messages, I agree that there are times in which MDC messages can be deleted or I mean, I worked in Nevada County where sometimes it was carrier pigeon, right? I mean, you don't know if you're going to get your MDC message or not. In this case, I think Mr. Evenson investigated that and proved to a clear and convincing standard that the responses made by Deputy Robledo to his sergeant indicated that he received those messages, not necessarily proving through the electronic system or through an audit of the MDC system that he received the messages, but clear and convincing evidence indicated that he received those messages because of his response and to whom he responded. And so respectfully, I just want to be able to provide that insight. And I do appreciate how sometimes those 12, 13 factors can look a bit prejudicial, but I believe it would be inappropriate as a regulatory organization not to show that those reports had come in and that we addressed them. I hope that answers some of your questions and concerns.
No, it does. Thank you. I think I would disagree with the statement about the MDC messages and that, well, you know, I understand with the Wash Sergeant, what their statements were, but again, that's their perspective and, you know, that they took that to be the case that this deputy did acknowledge them. It's not necessarily the case though. I mean, so that's my only point of contention on that.
I appreciate that. And from our perspective, we're using the clear and convincing standard and sort of as I indicated, it's more likely to be true than not is how we look at it. And we don't have to be beyond a reasonable doubt, though that would be very helpful. That's not where we were at with this particular issue.
Commissioner Terrell, if I could also point your attention to attachment C of the ISF. Within that, this is the transcript of the conversation between Deputy Strello and former Deputy Robledo. He does mention the text of that MDC where Sergeant Anatel was sending him the questions. So that's also evidence that he received that MDC, not just that it was sent to him.
No, I get that. I see that, but it's the issue with the sergeant, not the recorded line, as I stated. Like, I don't have an issue with the recorded lines. It's the issue with the sergeant.
But from Post's perspective and from having worked with Mr. Evanson on this particular ISF, he did look at that, not just that the issue was that it was sent, but also that there was other evidence to support that Mr. Robledo had actually read the MDCs and understood what they meant within the context of that stop.
No, understood. Thank you.
You're welcome.
Commissioner Gordon.
Follow up to that though, when you refer to Exhibit C and the phone call, the recorded phone call, the deputy's response is, I think the watch sergeant had typed, not sure. So in terms of the standard of clear and convincing, I'm just trying to figure out if we're hanging it on the MDC messages, you know, that's problematic for me in terms of that standard. You know, I think there's further conversation that can be had about the conversation between the deputy and the sergeant once he got back to the station. But I would just bring that up as a point of clarification in the clear and convincing standard when it comes to whether or not he received the MDC messages. So
Commissioner Doring? To touch on Commissioner Gordon's point too, it does seem like the initial portion of this case hinges on that MDC message being received and reviewed, and which led to the statements. And I just want to clarify with the division that this case is solely a dishonesty case due to the theft of the poker chips allegation was not sustained by the agency, and I don't believe it was sustained by Post, as the complainant either didn't comply with the remainder of the investigation. And in the report that we read, looks like there were some discrepancies discovered in his statement, which may or may not be why he didn't continue with the complaint.
Yes. So to your first point, the investigation was about a allegation of theft during a traffic stop. That was not ultimately substantiated because the victim, for one reason, the victim withdrew the complaint, essentially failed to cooperate any further with the investigation. And in that record, we indicate that the reason he chose not to follow up with that complaint is that he had heard the respondent was part of a law enforcement gang, which goes to why we included some of those things in the 1213 section earlier. But no, that was not substantiated. And the initial investigation, the dishonesty that we're speaking about is the sole allegation of serious misconduct. But that dishonesty is specifically the dishonesty that occurred in the internal affairs investigation, not necessarily, we're not citing the serious misconduct as the dishonesty that occurred between the watch commander or the watch sergeant and Deputy Robledo. It's the dishonesty specifically in the IA investigation.
And then just to clarify for the record, there were also the internal affairs investigation noted in our findings that in addition to the complaint about a law enforcement gang, there were also discrepancies in the complainant's statement regarding how many poker chips he had. There
That's
were
correct.
other issues in that investigation, correct?
That is correct.
Commissioner Nieto. The one thing I do want to point out about the investigation of this happened back in 2020. And they told it because of the criminal piece of it, which they didn't find any charges in the investigation. Like they said, found discrepancies, 500 versus the video shows 300 as far as poker chips. So they didn't have that finding. And what I'd like is that when we investigated as a commission, because some of the things said he stated he adamantly denied it, but when you read further, even under the video portion of, or when they played the audio of him, this is 4 years later. And, you know, maybe he was being honest. I don't remember that being my voice. I don't think that's indicative of being dishonest. Because he kind of stuck to his guns on some of that stuff. And I was thinking with myself, if you asked me what I did 4 years ago on something that may have seemed routine, maybe I would remember it, maybe I wouldn't. Because in the initial investigation, other than the statements between the lieutenant and the sergeant, it was very quick. They said, don't worry about it. And he went on with his business, and then the things that happened. And then 4 years later, he finally gets interviewed on it. So I would like us to look into that a little bit more to clarify just what his mindset is, because we have the ability to do that when we're doing our investigation, I think, versus their investigation on the officer. So there are issues. The other thing that I saw that I want to point out is that with the deputy gang issue, I think the original complainant just said there's deputy gangs. His brother or a relative told him there's deputy gangs, not saying that Robledo was part of that. And later, anything that had to do with deputy gangs actually was after the fact that came up. And so I don't think when we look at the case from 2020, what we find out 2 years later had nothing to do with the 2020 case and the dishonesty. It's not saying how I'm going to vote, but I just want to point out some of these things that I saw when I read the investigation.
That's very helpful. I appreciate that, Commissioner.
Commissioners, just to give you a little bit of clarity, we did prepare, since there was this question about timeline after the events of January 2nd, 2020, in the PowerPoint, how this went down afterwards. Mr. Robledo was offered an opportunity to be interviewed in the criminal investigation. As you all know, he does have that ability to decline to be interviewed. He, of course, declined to be interviewed. And then it went from there. The district attorney had the case for about 3 years. Since this was a potential felony, they've got about 3 years to make a decision as to whether or not they'll file. They took that time period, just made their decision on July 14th, 2023, and then returned it back to the agency. At that point, of course, POBAR kicked back in, and then the agency had another year to make its determination. So that's where the delay came in.
Mr. Chair, I have a question.
Commissioner Johnson.
Thank you. This is in relation to the exhibits, and my questions regarding the investigative need or conclusion. So what led up to only including the selected pages, especially when it comes to the transcripts with both the deputy that we're talking about and the transcripts with his coworker, the supervisor and the watch commander? It's a very selected amount of testimony or interview that they provided. So I'd like to know what the investigative reason or legal conclusion led up to only including a select amount of those interviews.
The reason we only included the portions of the transcripts that were relevant to the ISF is because those were that was the evidence that was just relevant to this particular portion of the ISF. When we go to the full evidentiary hearing, obviously the entire evidentiary record would come in. And then at that point, Officer or Mr. Robledo would be able to present any evidence that he would have in the mitigation, anything that he would be able to argue, possibly is evidence that would show that maybe his recollection was not very clear 4 years later. Although, having looked at the full transcript, I can say that he does present a very detailed recollection of the events, as Mr. Ringloff did indicate earlier in this hearing. He was able to provide details about the stop with the complainant, talking about the weight of the backpack, talking about what he looked for, that sort of thing. But all of these issues would be things that could be fleshed out during the evidentiary hearing.
Commissioner Gordon?
I would just ask staff, when you're asking the commission to vote on these matters, we should have the full transcripts of all of the investigation for us to make that decision as to whether we think it should move forward. And before we're making a determination on whether this deputy should no longer have the ability to be a police officer in the state of California. When there are other interviews that are between the supervisor and the IA, like that, their recollection of it also makes a difference to when we're looking at this. So staff should be providing all of that if it's available to us to look at and determine the relevancy for us as we make this decision, because the corroborating evidence of what the supervisors remembered about the conversation, their recollection of the memory of the conversation, when we're, making assertions about dishonesty, all of those are relevant in looking at that. So I would ask that, to Commissioner Johnson's point, that we actually get all of that information provided to us when we're making these decisions. I understand that the ALJ can go through all of it and it can be a full hearing, but we're making a decision and we should have that information to base our decision off of. So to me, in terms of what we're being presented, we're lacking, I think, some material in terms of making our determination, so.
Commissioner Doring, I'd like to echo Commissioner Gordon's concern. I feel like the comments that were just made indicate that there are other pieces of substantial evidence from his statements that we would like to review, and it's this commission's decision to send it to an ALJ if we're not being able to review that documents prior to make that informed decision. I feel like that's a disservice a little bit to us. So going forward, I would love to see the full documents.
I do want to point out to the commission as a whole, though, after the evidentiary hearing, you would be provided with the full evidentiary record to make your final decision as to whether or not to revoke, suspend, or take no action as to this officer's certification.
But I would also note on that, we're putting in a great deal of time. Staff is putting in a great deal of time. The ALJ would have to put in a great deal of time, and then to have it come back when we could possibly work through those issues at this point. I understand there's other opportunity, but I would just, I'm going to reiterate the request to make sure that we have that full evidence when it's available, like it is in this case.
Commissioner Terrio, that's not the intent on how SBT was created. It was created for this body to decide on the front end and to be able to provide it all that available information. It should have been provided. If I have no problem weighing in and terminating someone's ability to be in this profession, because I don't want people who shouldn't be in this profession. However, I'm going to do so. I need to be able to do so with the full scope of information, and to not be provided that is a problem with due process. It's unacceptable. I won't be as diplomatic about it as my colleagues will, but that has to be provided. I have no problem taking action on stuff. Now, I was halfway thinking to do so, but after hearing all this, there's no way. That has to be provided. If we're going to be able to be providing, things on the front end that other things were not sustained and were investigated or sustained, and providing that on the executive summary, then why wouldn't we provide all the things that maybe could be exculpatory for the officer? Makes no sense. Thank you.
Further question or comment from the commission on? Let me ask then if Officer Robledo or his counsel wish to comment. I believe we're online there. Welcome.
Commissioners, I'm Elizabeth Gibbons, counsel for Deputy Robledo, and I thank you for this opportunity to address you about this case. To pick up on what some of the commissioners said, I think that the selective portions of the transcripts that were provided to the commission are extremely misleading. I know that counsel is trying to limit this allegation to the IAB investigation, the alleged false statements, but those all deal with the alleged false statements made the day of the incident. So there's a couple of important things about that I wanted to bring to your attention. First of all, Deputy Robledo in his IAB interview very clearly stated that he called the watch sergeant not in response to those MDC messages, because he said he deleted them and he didn't read them, he just deleted them. But he had a conversation with the watch deputy, Manny Palacios. Now, significantly also omitted from any reference at all in this case is the fact that Manny Palacios did speak to the complainant. And when Manny Palacios, the watch deputy, spoke to the complainant, all the complainant complained about was that he wasn't told why his car was searched. That's all he complained about. And what he said was specifically that he didn't know whether it was a deputy or CHP officer. So even beyond that, what he said was he asked me if he could look in his car, and I said, sure, go ahead. And then when he came back not finding anything, because I knew he wouldn't find anything, I asked him, why did you search my car? And he said, don't worry about it. So he makes absolutely no allegation that any money was missing or any chips were missing. He tells Manny Palacios this story, and Deputy Palacios says to him, look, he has every right to detain you and investigate this because you're driving with an expired license, tag on your license. And so the guy didn't like that answer. And an hour later, he calls back and says, oh, he stole $500 of chips from me. Then when we look at the video from the casino, he didn't have $500 worth of chips. He only had $300. But more significantly than that, he had almost $2,000 in cash. Now, it just makes absolutely no sense that a deputy sheriff assigned to the commerce area is going to steal a casino chip that he can only use or cash at the casino where he works, that he knows has cameras everywhere in it. When there's $2,000 in cash he could take, if his point is to steal something. So that part of the story doesn't make any sense. He doesn't When he talks to Palacios, Palacios tells him, I think the watch commander's looking for you. So that's when he calls the watch commander, and the watch commander's not available. So he doesn't remember the conversation with Strelo because he's calling because Palacios told him, and Strelo says he's not there. Now, he doesn't know Strelo like he knows Palacios, so he's not paying attention as much to the conversation with Strelo as he did with Palacios, because he got all the information he thought he needed from Palacios, which included, to the best of his recollection, that this stop occurred in, he said first in Montebello, and then he said something else. Now, he didn't really say that to Palacios, but that was what Roblato recalled 4 years later when he was first asked about it. So if you look at what the two supervisors said, both of them said they didn't really remember. They were interviewed 3 times. The first time, 4 months after the incident. When they were interviewed 4 months after the incident, both of them did not have a good recollection of their conversation. Both of them, however, said, the sergeant said, I asked him, did you stop this car? The lieutenant said, did you stop this guy? Neither one of them said, did you make a stop in front of the Commerce Casino? And throughout this entire investigation, and frankly, in the last meeting, when that board was ready to send it back for further investigation, counsel said that both of those supervisors told him that the stop was made in front of the Commerce Casino. Neither one of those supervisors ever said that in any of their 3 interviews, ever. They never said that to him. They never said that they said that to him. They said, did you
Ms.
stop
Gibbons,
the guy?
excuse me, if you could begin to wrap up.
I'm sorry. I apologize for
No,
taking
no.
too much time. I
You could
get a
begin
little
to wrap up.
hyped up.
Thank you very much. ma'am.
Sure. The other thing I wanted to point out is that the regulation specifically requires that the dishonesty relate to the reporting or investigation of misconduct. That would be the theft of the poker chips. At the time that he was talked to by Palacios, there was no allegation of theft of poker chips. There was no allegation until an hour later, and nothing in the MDC messages says anything about a theft of poker chips. Both of the supervisors say when they talked to Roblato, they did not tell him that there was an allegation of theft of poker chips. His statements to them could not have been related to any allegation of misconduct because they told him there wasn't any. And there was nothing wrong with that traffic stop. When he was interviewed later by IAB, you have to remember that in the interim, in that 4-year period, there was a DA reject letter that was issued. And it was highly publicized in Los Angeles area because it contained this overstated claim that there were deputy gangs at East LA Station, and the guy was afraid to make any more comment. The fact of the matter is the guy made up the complaint. He lied about how much money he had, and that's why he backed out of it. But that was never, ever told to Deputy Roblato. That makes the statements to the IAB or to the supervisors at the time a direct violation of the Peace Officers' Bill of Rights. And again, when he's interviewed by IAB, he now knows what the allegations by the guy are. So that's why he can remember the stop, because the guy says, oh, he wanted.
Ms. Gibbons,
Okay.
we've gone several minutes over the limit, so
I'm
why don't
sorry.
you take a few seconds and just wrap up, and we appreciate you taking the time to appear before us.
Sure. The publicity about the stop itself is what gave Deputy Roblato in the IAB interview 4 years later a recollection of what happened in the specifics of the stop. and why he didn't look in the bag and everything he said about that in his IAB interview, which is again not included in your summary or the documents that are given to you. Deputy
Thank you.
Roblato didn't lie to his supervisors. He didn't know what they were talking about. They admit they
Fair point.
didn't tell him.
You've asked her to stop, would you? So point of order, sir. Brazil,
Oh, yes.
point of
Commissioner.
order. It's time to discontinue the
Yeah.
conversation.
Yeah, Ms. Gibbons, we need to end this now. 5 minutes is our general time. We've given you several minutes over. So thank you very much for taking the time to appear before us and offer your thoughts. Thank you very much. Back to the commission. Or the division. Any comments or questions? Commissioner Gordon,
Can I make a recommendation? We go to closed session?
absolutely, always in order. All right.
Prior to closed session, can we, I need a little bit of information from, council on what the direction is actually according to the penal code and what our charge is, in this hearing here. So that would help us, I think, before we go into closed session.
Maybe just being a little more specific with question.
Perhaps on behalf of the division, I think I perhaps understand it, Rick, if you'd like me to talk about it. So William Darden, Chief Counsel, speaking on behalf of the division now, and also addressing some of the concerns of the commissioners about the nature of the information that was included in the ISF and that is before the commissioners today. So just a reminder to the commissioners, we're not asking you today, and the statute is not asking you today, to make a final determination of guilt or innocence or whether these officers in fact engaged in these acts. That, according to the Senate Bill 2 statute, is something that is going to be determined at the full administrative hearing. Most licensing schemes in California, except this one, there is no such hearing as you're having today. Staff makes the determination that a case should go to an ALJ, and then that ALJ hearing occurs, and then the first time the board, or you, the commission, would hear about it is after that full record had occurred. One of the things that I, as chief counsel, have had to balance in terms of how we interpret Senate Bill 2 and how much information we can provide and should provide to the commission at this very early stage of the proceedings is that, of course, all the information that we attach to the ISF becomes public. And of course, as you're aware, in some of these extensive IA investigations, you may have 500, 600, 700 pages of information, much of it that doesn't relate to the specific allegations that the division has found warrant discipline. And so attaching that full transcript, the full IA would be problematic for those reasons. But keep in mind, you're gonna have that ability because when the case goes to the full ALJ and the full ALJ writes the opinion and it then comes back to the commission for you to make a final determination after all of the information has been fully vetted and the full record has been presented to the ALJ. So that's just the quick concern about, if we attach the full transcripts and the entire IA at this early stage, then we run into people saying, well, you're putting your thumb on the scale. There's a bunch of information in there that shouldn't have been in there. A bunch of information that really is irrelevant. What the statute says is that the division, we hire experienced investigators, law enforcement officers. They review it. They find in the record information which they believe establishes clear and convincing evidence. And this is really, in my view, I don't know if you want to call it a gut check, but it effectively is. It's the division believes we can prove X, Y, and Z facts. And what the commission here is charged to do is simply say, look, the divisions look through it. They believe they can prove X, Y, and Z facts. If those facts can be proven at the later administrative hearing, do you, the commission, believe that that amounts to serious misconduct? So that's one of the reasons with respect to the determinations that we've made about the extent of the record that we provide, because it's that careful balancing act, and it's not to prevent you from getting that information. You certainly will have the benefit of it at the full later administrative hearing. I don't know, Rick, was that your question or did you have another one?
No, that was it. I think that, and I continue to express concerns that we seem to be doing an evidentiary hearing here when that's
Right.
not our charge.
Correct.
Our charge is to, if the facts are that are.
As alleged by the division.
Alleged by the division to us. If proven in a full evidentiary hearing, would that be serious misconduct?
Correct.
And-
That's
and-
correct.
And I know we're all A triple plus personalities who want to get to that end, but I don't think that's our role right now. It's more like a preliminary hearing in a criminal case. The DA doesn't present all the facts, they present enough to convince a judge that they should go to a full trial. And I think that's the equivalent of what our role is here, with a lower standard than you would have in a preliminary hearing. I just
That's
hate to
correct.
see it, and again, the council, that's all well and good, but she was trying her case in front of us versus addressing the facts. And again, we're trying to reel this back into what is our role at this moment in time and not what is our role downrange after a full evidentiary hearing. So I'm just trying to bring us back to what our job is right now.
That's correct. That's 100% correct. And again, we're balancing a lot of different concerns, and the statute has as well. Keeping in mind that everything that's put in the ISF and that comes before you becomes public. And so that would require, a lot of redaction, but it would also just involve the presentation of a bunch of evidence that our trained and experienced investigators that have reviewed these IAs have determined are not relevant to what's happening today. And that's just, here's what we believe we can put in a complaint. Here's what we believe we can prove. If we can prove it, is that enough? So you're absolutely right, Commissioner Brazil. That's the charge that the legislature gave us. And if the legislature wants to change it and bring this more in line into a licensing scheme like many others that we have in California, it can. But until it does that, this is what we have.
Additional questions or comments from the commission before we go to closed session, we will ask for public comment, but anybody else like to make comments or ask questions of division staff? Then I'll ask if there's anyone from the public who would like to comment on the case, please come forward. You have 3 minutes to speak. Welcome again.
I'll also be speaking about, speaking to the impact statements of community members, but the first segment is mine. You can't reason with police gang activity, whether it's unjust violence, biased policing, lying, illegal arrests, or stealing. You can't negotiate with it, sit at the table with it, or save their jobs after they violated Senate Bill 2. This officer was terminated by his department. I'm reading community impact statements from the communities who were unable to attend today and who are directly affected by these officers' misconduct. LA County, we call on you to affirm the board's recommendation to decertify Barillo Robelido, I'm sorry if I said his name wrong, a known member of a law enforcement gang who conducted a pretextual traffic stop of a community member, stole from that community member during an illegal search, and then lied about it. Lying about a pretextual stop and stealing is serious misconduct in and of itself. And on that basis alone, the commission should uphold this individual's decertification. But we also want to emphasize that prior misconduct investigations post-conducted should not have been closed without action. We note that Robelido has a prior sustained finding that he engaged in dishonesty about his improper use of police data. But for some reason, Post decided that misconduct finding did not warrant action. We also note Post closed without action its investigation into Robledo for law enforcement gang participation for insufficient evidence, even though 2 separate deputies reported him for being a gang member. As a result, we are concerned about the rigor and completeness of Post investigations. The commission should not allow this individual to continue escaping accountability and going about his pattern of harming the community. It's time for him to be decertified now. In San Diego, we noticed that you recently overturned the advisory board's recommendation to decertify Dylan Fustan, a dangerous officer that has repeatedly caused harm to community members here in San Diego. You opined that the serious misconduct the officer engaged in, dishonesty to conceal his excessive force, and the extent of the injuries of the victim of his excessive force wasn't established by clear and convincing evidence. Without any explanation justifying your decision to diverge from detailed findings and recommendations of Post's own investigators and the advisory board, By doing so, you have endangered the broader San Diego community. We also noticed that during the November commission meeting, it was reported that you have overturned the board's recommendation to take action insulating officers that have caused harm from accountability in 50% of the cases that you have heard. This is unacceptable, particularly because it's apparent that Post is presenting an overly narrow set of cases to you and the advisory board. We are here today to say you should not make the same unjustified decision to overturn Barilio Robledo's decertification for dishonesty to cover up his harmful acts. And you should take more serious your statutory responsibility to protect us from officers that have engaged in serious misconduct. Thank you.
Thank you. If there's no one else that would like to address the commission and there's no one online, then we will adjourn now into closed session. This is the best room we've got, so regular session, I suggest that this conversation, if we have time, could proceed offline before we all leave. So I think we're onto something here. We should follow it up and not let it drizzle away, right?
Chair, are we outside of closed session? Are we back in session?
We're back in regular
Right.
session.
I'd like to move that we accept the board's recommendation, move towards revocation.
Second. Cooper.
Mr. Knapp, would you please call the roll?
Yes, thank you, Mr. Chair. Barcelona.
Aye.
Barcelona, aye. Braun. Braun, aye. Brazil.
Aye.
Brazil, aye. Cooper.
Aye.
Cooper, aye. Doring.
Nay.
Doring, nay. Yule.
Aye.
Yule, aye. Gordon. Gordon, aye. Johnson.
No.
Johnson, nay. Long.
Aye.
Long, aye. Moon.
Aye.
Moon, aye. Nieto.
Aye.
Nieto, aye. Terrio.
No.
Terrio, nay. Woolry.
Aye.
Woolry, aye. Mr. Chair, that's 10 in favor, 2 nays.
Motion carries. Motion
Excuse me,
carries.
excuse me, a point of clarification. I think the vote's inaccurate.
3 no votes, right?
3 no votes, 10 ayes.
Yep. All right. We'd already touched on future commission meetings yesterday, so that was being the last item on the agenda. Is there a motion to adjourn?
Resolve. I'll defer to Dorian. Dorian went first. You're good.
Is there a second?
Resolve second.
Is there objection to unanimous consent? Seeing none, we are adjourned. Thank you, everyone. Thank you to staff. Thank you to the commission for